Hello and welcome to the Shafi Law YouTube channel where we explain your rights in plain English. My name is Cheyenne Shafi, criminal defense lawyer in the city of Toronto, and today we're going to be addressing a question that I get asked multiple times every week. Can you get the no contact order dropped in a domestic violence case? All right, first things first, the quick answer to that question is yes. There are multiple ways, in fact, that the no contact order in your case can be removed. But before we get there, let's talk very briefly about why a domestic violence complainant may want to get a no contact order removed. The answer to that is not simple. No two domestic violence complainants is alike, and no two domestic violence cases is alike. But there is one thing that is universal in the province of Ontario, and that is the police must charge policy. What this translates into in practice, as a criminal defense lawyer practicing on the front lines in this field, is a large volume of unwanted charges. That's right. There are many domestic cases in our Ontario courts that were not supported by the complainant at the time that they were laid and continue not to be supported by the complainant as they make their way through the court process. In these cases, usually where the allegations are very mild and usually where the couple have had no previous contact with the police, the complainant and the defendant both want to reconcile. The only thing getting in the way is the no contact order. Now, with those two primers out of the way, and I will note that I intend to make a video in the coming weeks on the rights of domestic violence complainants because I think there's just so much misunderstanding and mythical thinking about this subject matter. Let's talk about the 3 ways that a domestic violence no contact order can be lifted. If you think of a criminal case as having a lifespan that begins at the time of arrest and follows through to the very disposition of the case, by far the most common way that a no contact order is lifted is at this very end point, when the court case is terminated. Now, a court case can terminate in a variety of ways and for a variety of reasons, but suffice it to say for our purposes that in the vast majority of domestic violence cases, if both the complainant and the defendant want to reunite at the conclusion of the case, the court will permit them to do so. In very unusual cases or cases of extreme seriousness, the court may impose a no contact order even if the complainant wants to reunite. Talk to your criminal defense lawyer if you want to know what the risks of this occurring are. The second most common way that a no contact order can be lifted is through what's called a consent bail variation. A consent bail variation occurs when the lawyer for the accused and the lawyer for the prosecution, or the Crown Attorney, agree to lift the no contact order. Consent bail variations are a common feature of domestic violence cases where the defendant has been approved for either the early intervention program or the PAR, or partner abuse response program. Again, talk to your criminal lawyer if you'd like to know more about these programs and whether or not you, if you are a defendant, are eligible for entry into these. So far, we've talked about the most common way that the no contact order is lifted, and this tends to be the most unsatisfying because it requires the parties to endure no contact for the entire duration of the criminal case. We've also talked about the consent bail variation, which typically occurs when an accused person has been approved for either the EIP or the PAR program. Although this method of lifting the no contact order doesn't require you to wait until the very end of the case, it still requires the lawyers a reasonable period of time to negotiate the case outcome. Additionally, consider that in this scenario, the Crown gets to call the shots. In other words, if the Crown does not consent to the variation or does not permit the accused to enter into the two programs that I've mentioned, you will continue to be bound by the no contact prohibition for as long as it takes to dispose of the case. Which leaves us with the third option, which is by far the most dynamic, the most litigious, and the most, in my view, exciting. The third way of getting a no contact condition lifted, if it comes from the police, is to bring an application in court. A criminal court judge has the power to review the terms and conditions that have been imposed by the police and make a determination as to whether or not they are necessary. These types of applications are still fairly rare in our court system because in the vast majority of domestic cases, the no contact condition goes uncontested unless and until the Crown Attorney consents or the case is dismissed. However, I happen to be a huge fan of these applications for one principled reason. They allow the defendant and the complainant to reclaim their own autonomy and decision-making power. In a landscape of domestic violence laws where accused people and complainants have very little voice, this kind of procedure is extremely powerful. Instead of passively allowing the police or the Crown Attorney's office to dictate the terms of their relationship with their husband or their wife, they force the courts to scrutinize the conditions imposed by the police and after reasoning their way through the process, either approve them or in many cases, reject them. Because these types of applications are done in court, the accused person should have their own lawyer. This is a highly technical process. Additionally, the complainant should have his or her own lawyer and have received independent legal advice. Therefore, if you have the appetite, the will, and the money to spend on this type of unique application, consider speaking with your criminal lawyer about it. So that's it for our talk today. I hope that you found this information helpful. I decided to make this video because of the sheer number of calls that I was getting from domestic complainants, especially throughout COVID-19. Hopefully this sheds some light on some of the things that you can do to reclaim your voice in the criminal justice process. If you did find this content useful, please hit the subscribe button, hit the like button, and watch out for future videos where we explain your rights in plain English. My name is Cheyenne Shafee, and if you need legal advice in respect of a case, please don't hesitate to contact my law firm. I'll leave our number and contact information in the description below. Stay safe.